Welcome and thank you for standing by. At this time, all participants are in a listen-only mode. During the question and answer session, please press star 1 if you would like to ask a question. Today's conference is being recorded. If you have any objections, you may disconnect at this time. I will now turn the meeting over to Ms. Donna Hengeveld. Ma'am, you may begin.
Thank you, Amy. So welcome to the first module of the International Case Processing under UIFSA 2008 webinar series. And first, I would like to introduce Yvette Riddick, the Director of Division of Policy and Training at OCSE, for opening remarks.
Hello, this is Yvette Riddick, and I wanted to let everyone know that I am very, very happy that OCSE's Division of Policy and Training can announce the first module in the series of 8 that we will be providing, and they're all related to the Hague Child Support Convention. I know that in the future there will be a lot of people out there who want to provide the information, and especially trainers in the child support program at the state level. And therefore, what you see today is the beginning of a comprehensive curriculum that we will be providing to the states in the future via the actual website, and also through as-needed basis, and perhaps through a listserv. So that will also be accompanied with notes and so forth. So we're really, really excited about that. And I just want to end by acknowledging Donna Hengeveld, who will be moderating and facilitating this particular webinar. She is our Region 10 Regional Program Manager. She has worked very closely with us in central office on intergovernmental affairs, and so we're really pleased that she is leading this for us today. So thank you for participating.
Thanks, Yvette. So, yes, welcome to the first module, and the trainers today are Ann Miller and Liza Lowe, who are Senior Policy Program Specialists at OCSE, as well as Meg Haynes, who's an attorney with the Center for Support of Families. We're really lucky to have Meg, who's a national expert on the Hague, working closely with us at OCSE to develop this training series. So next slide, please. I can't hear. So we understand that some of you in the audience today have attended multiple conference presentations where the background of the convention have been explained, as well as an overview of UIFSA 2008. But for others of you, this information will be brand new. And we've designed the content of this session and other sessions to cover both audiences. We really hope that states will use the webinar resources for internal training of staff, as Yvette mentioned, and some of those will have very limited information about very limited information about the convention. So the series will include resources of the PowerPoint slides, instructor notes for the slides, and an expanded set of Train the Trainer notes. We're going to be making these available on our website, and those of you who are on the webinar today will get them emailed to you. Next slide. So the first 2 modules of the series are overview modules, and they provide a background information about the Hague Child Support Convention so that you understand the U.S. goals during treaty negotiation and the process used for negotiating an international treaty, as well as the terminology in the convention. They also discuss the scope of the convention and services that a central authority must provide, so you will have a better idea of what to expect on outgoing cases to a convention country. Once we get into Module 3, we will start focusing on case processing. The most likely application under the convention is an application to recognize and enforce the support order that's been issued by a convention country. So for that reason, there is one module explaining the process and forms for incoming application, and a separate module explaining the process and forms for outgoing applications. Module 5 examines incoming and outgoing applications for establishment of a support order, including establishment of parentage where necessary to obtain support. Module 6 examines applications for modifications under the convention, and in Module 7 we will address implementation issues and questions that have arisen. Finally, in Module 8, we will discuss processing international support cases from bilateral countries that aren't convention countries. So now I want to get into the meat of the webinar and turn it over to Ann Miller.
Hi, everybody, and thanks, Donna. Module 1, as Donna mentioned, will provide a background on the Hague Child Support Convention and discuss the negotiation process. Then we're going to take a break for Q&As. And the second half of Module 1 will discuss the terminology used in the convention and highlight UIFSA's role in implementing the convention in the United States. And we'll conclude with a chance for Q&As and feedback at the end. Next slide. And the next slide. Thank you. All right. The Hague Child Support Convention is not the first international child support treaty. Since the 1950s, there have been a number of international child support treaties. The most widely adopted was the New York Convention of 1956, which was sponsored by the United Nations, and over time, more than 60 countries joined it. There were 4 Hague Maintenance Conventions developed in the 1950s and 1970s, and there are also regional conventions, such as the Inter-American Convention on Support Obligations from 1989. The U.S. was never a party to any of these earlier treaties. The largest problem was a legal one. In most countries around the world follow child state jurisdiction, which allows the establishment of a child support order in the country where the creditor or child lives, regardless of any contacts of the debtor with that country. In contrast, the U.S. Supreme Court has held that personal jurisdiction to establish a support order is based on contacts between the debtor and the forum, and the relevant case is Kolko v. Superior Court. As a consequence, states negotiated reciprocal arrangements with countries, and in 1996, Congress changed our approach and passed the Personal Responsibility and Work Opportunity Reconciliation Act. And this federal legislation contained major reforms to child support. One of the provisions authorized the State Department, with the concurrence of HHS, to declare a country as a foreign reciprocating country if it met certain requirements. And this was the first time there was legislation authorizing federal bilateral arrangements. In order for the U.S. to establish a country as a foreign reciprocating country under Section 459A of the Social Security Act, that country must have in effect procedures available to U.S. residents for the following: the establishment of paternity, the establishment of support orders for children and custodial parents, and the enforcement of orders for children and custodial parents, including procedures for collection and disbursement. These procedures must be available to U.S. residents at no cost. Currently, as noted on this slide, the U.S. has reciprocal arrangements with 14 countries and 12 Canadian provinces and territories. These arrangements take precedence over any state reciprocal arrangement. However, Section 459A of the Social Security Act permits states to enter into reciprocal arrangements with countries that are not the subject of a federal declaration. Because of the huge investment of time and resources to negotiate a new child support treaty, the Hague Conference on Private International Law wanted to establish that there was a clear need for a new international agreement, that there was consensus on its main components, and that countries would likely ratify and, more importantly, implement it. So beginning back in 1995, staff at the Permanent Bureau analyzed defects in existing treaties and sent out questionnaires to member states. This led to 2 special commission meetings in 1995 and 1999. Permanent Bureau representatives also reached out to the U.S. to determine what a child support convention needed to include in order for the U.S. to be interested in joining it. They recognized that countries would be more willing to ratify the treaty if they knew that the United States was also a contracting state. Satisfied that there was sufficient interest and agreement on key components, the 19th session of the Hague Conference issued a mandate in 2002 to begin negotiations on a new global child support treaty. This 2002 mandate included an endorsement of the recommendations of the 1999 Special Commission regarding what should be some basic features of the new convention. An essential element would be provisions relating to administrative cooperation among central authorities. They wanted it to be comprehensive in scope, building upon the best features of the existing convention. It should also take into account future needs, the developments occurring in national and international legal systems to recover maintenance, and the opportunities provided by advances in information technology. And finally, it should also be structured to combine the maximum efficiency with the flexibility necessary to achieve widespread ratification. I'm going to turn the presentation over to Meg Haynes now, who was a member of the U.S. delegation at the Hague negotiations. Meg?
Thanks, Ann. Negotiations of this new Hague Child Support Convention began in 2003, and it continued over 5 years. So in addition to the United States, the participating countries were the 54 other countries that are members of the Hague Conference on Private International Law. And we'll talk about this some more, but you'll hear us referring to them as states. That's the terminology that the convention uses for a country. There were also observer countries, and there were some non-governmental organizations. Some of them that you would be familiar with are the National Child Support Enforcement Association, NCIA, and some of the bar association groups, such as the International Bar Association. Next slide. Before this first special commission in 2003, the Permanent Bureau prepared several background reports, and what they tried to do was look at different child support issues. For example, one report focused on various laws and procedures that countries use to establish parentage, and also looked at whether countries recognize and enforce a foreign support decision if it's based on a determination of parentage contrary to how the requested country establishes parentage. And in developing all these background reports, they were using the responses that Hague member countries gave to a 2002 questionnaire. So if you are really interested in even getting more detail about the background of the convention, you can go on the Hague Conference website and see these background reports. Beginning in 2003, there were 5 special commission meetings. A commission meeting is a meeting where all the country delegates come together and they discuss, the proposed treaty provisions. So there were 5 of those special commission meetings, and there was a final diplomatic conference, all of which totaled about 15 weeks of formal negotiations. Everything is translated into French, English, and Spanish, so all the delegates are sitting there with their headphones on listening to simultaneous translations. It really was an incredible experience, and one of the things that I was struck by is just how much the discussions are diplomatic and very polite. For example, you would never say, I don't agree with what you're saying. Instead, you would say something like, I appreciate the comments of my learned colleague from the country of Moliere. However, he does not fully appreciate the time delays involved. It's all very, very elegant, very diplomatic. And so decisions are also made through very much a consensus approach. There's no voting by majority. people talk through different issues, and at a certain point, the chair would note the consensus decision, and at that point, the drafting committee would try to reflect that decision in treaty language, and then that treaty language would be brought before the delegates, and that was also subject to consensus approval. So consensus doesn't mean decisions were unanimous, but it does mean that there was a general agreement on all of the provisions of the treaty. In between these special commission meetings, there were also meetings of a number of working groups and committees. There was the drafting committee, there was the applicable law working group, the administrative cooperation working group, and the forms working group. And we had U.S. representatives on all of these, so that was very important. Representatives from the U.S. Also met a lot in between. So we weren't just at these working group meetings and at the special commission meetings. We also met in the mornings and the evenings of each day to kind of strategize. Next slide. And what we were meeting and strategizing about was how to achieve the United States overall negotiation goals. There were 3 of those goals. First, the convention had to be one that the United States could join. So the United States was willing to compromise on some issues, but there were others that were deal breakers. One of those deal breakers was the scope. The mandatory scope had to be limited to child support and the enforcement of spousal support in conjunction with child support. In other words, the mandatory scope had to basically be limited to the current scope of the 4D program. We didn't want 4D agencies having to be providing additional services that they don't get funding for. The convention could not require recognition and enforcement of orders where jurisdiction was based solely on the fact that the creditor and child resided in the country. As Anne discussed, that type of jurisdiction is contrary to U.S. law, and what the Supreme Court has held meets our due process standards. So we would not be able to sign on to a convention if it required recognition and enforcement of those kind of orders. The convention had to cover establishment of support, including establishment of parentage. We were not interested in a convention that just addressed enforcement. And the convention had to provide that all of the services were cost-free or virtually cost-free to the creditor. So that was our first goal in terms of a convention that the United States could ratify. The second goal is that we wanted a convention that would actually result in more money, reaching more families more quickly. That meant the treaty had to address practical issues like time frames and forms and procedures that the central authorities had to follow. It meant there had to be improved procedures for recognizing and enforcing orders. We didn't want the tribunals in one country spending a lot of time reviewing and second-guessing decisions of another country. It was also important to us that debtors had limited defenses that they could raise to object to an order that had already been established. And finally, there needed to be assurance that a ratifying country had the laws and the procedures necessary to implement the convention, because the U.S. goal wasn't to have all the members of the Hague Conference sign the treaty just because they thought it was a good idea. The U.S. goal was to have countries develop the necessary laws and procedures and then have them ratify, because that meant they could actually carry out the terms of the convention. The third negotiation goal of the U.S. was that the convention needed to be one that would be widely accepted. And that meant that delegations, including the United States, had to be willing to compromise in order to reach consensus. So it was a very long process, an intense process, but a very rewarding process, because The final diplomatic session was held in November 2007. The convention was approved, and the United States was actually the first country to sign the treaty. That indicated the U.S. intent to work toward ratification of the treaty in the United States. So believe it or not, there was actually a rainbow that appeared right as the signing ceremony was going on. So that was really pretty neat. What you see on this slide is a picture of the U.S. representatives who helped make the treaty happen. Just wanted to give you an indication of how large the U.S. presence was. The official United States delegation included officials from the Department of State, the Federal Office of Child Support Enforcement, Bob Keith from the Office of the General Counsel of HHS, representatives from the Uniform Law Commissioners, and subject matter experts. There were also U.S. child support experts who were members of delegations of other groups, INSEA, the International Bar Association, the International Association of Women Judges, the International Society of Family Law. All of them had U.S. representatives. And I think that's why you see so much of U.S. laws, procedures, an emphasis on time frames that's built into this convention. The Hague Child Support Convention went into force in 2013 when the first two countries had ratified it, and those countries were Norway and Albania. So I'm going to turn it over to Anne to talk about U.S. ratification of the treaty.
Thanks, Meg. Just a few months ago, on September 7th, 2016, the United States ratified the Hague Child Support Convention. And it was a long road to get to that important day, as noted on this slide. The Senate gave its advice and consent to ratify the convention on September 29th, 2010. Congress then approved implementing legislation in the fall of 2014 called the Preventing Sex Trafficking and Strengthening Families Act. And among the Act's child support provisions is a mandate that the Secretary of HHS ensures U.S. compliance with any multilateral child support convention to which the United States is a party. It also requires that a state enact UIFSA 2008 as a condition of receiving federal 4D funds. UIFSA 2008 is the law that will implement the convention in U.S. states. Once every state had enacted UIFSA 2008, which occurred earlier this year, President Obama was able to sign the U.S. Instrument of Ratification. And on September 7th, 2016, the United States deposited this instrument with the depository for the Hague Conference in the Netherlands. What this means is that the Hague Child Support Convention will go into force in the United States on January 1st, 2017. So currently, the convention is in force in 31 countries, including the European Union. Effective January 1st, as I mentioned, it will go into force in the United States, and it will also go into force on that date in Montenegro. Most recently, Turkey ratified the convention, and it goes into force in Turkey on February 1st, 2017. Once the Hague Child Support Convention goes into force in the United States, we will immediately have a treaty arrangement with 32 convention countries. Some of those convention countries are foreign reciprocating countries under existing bilateral arrangements, but 22 of them are brand new treaty countries for us. We'll continue to have a bilateral arrangement with 16 foreign reciprocating countries and Canadian provinces and territories that are not a party to the convention yet. UIFSA Article 7 will become effective on January 1st, 2017, and that's the new article of UIFSA that only applies to Hague Convention cases. And on January 1st, 2017, state child support agencies can send and receive new cases under the Hague Convention. pre-existing cases with Hague countries will continue to be in place and worked as before. However, when a major action is needed, such as an application for enforcement or modification, it should be done prospectively using convention forms and following convention requirements as provided for under UIFSA Article 7. As Meg described earlier, the convention is an incredible advance over the status quo. Under prior treaties, procedures for recognition and enforcement of existing support orders were dependent upon a country's domestic laws. And that often meant extensive reviews and delays by a foreign court, which resulted in long delays in enforcement. The convention will greatly speed up the enforcement of U.S. orders. It limits the circumstances under which a court can review and object to an order. It requires recognition of a U.S. order unless a respondent timely raises a challenge, and it limits available objections that the respondent may raise to those similar to ones now allowed under UIFSA. Without reciprocity, the costs of attorney fees and court actions in international cases can exceed the amount of support collected. Under the convention, treaty countries are required to provide free legal assistance in child support cases. Child support agencies in the U.S. already provide such assistance, and now other treaty countries must provide cost-free services to U.S. residents. The convention provides standardized procedures and timeframes. Under the Hague Treaty, each country must follow certain procedures to recognize and enforce child support orders. They must meet certain timeframes for allowing a challenge to an order and for providing status updates. And additionally, there are recommended standardized forms that will reduce the need for a country to request additional information. So as a result of U.S. ratification of the convention, more U.S. families will receive timely support without regard to whether both parents live in this country. That concludes the first half of the webinar with the background of the convention and the overview of the negotiation process and kind of the current status of where we are. Donna, would you like to open the floor to see if there's any questions on this first part of the presentation?
Absolutely. So Amy, can you be ready to watch for people to raise a question? And for those of you who have questions, if you press *1, the operator will open your line. And my apologies, I didn't point out that you can use, those of you on WebEx can use the question feature in there to ask your question, and I see that there aren't any that have been added in WebEx yet. Amy, do we have any on the phone?
Currently, there are no questions on the phone. Once again, that's *1 if you have a question.
Okay, thanks, Amy. Well, I have a question.
Hey, Donna, there is a question in the chat feature.
Oh, I guess I can't see it.
In the Q&A, it says, so does the convention trump foreign reciprocating status if country is both? Our guidance on that issue is that the convention, if you are currently working a case with a foreign reciprocating country, you should continue working that case as you do now until an application is needed for an action, such as modification or enforcement. At that time, you should proceed under Article 7 of UIFSA and proceeding with that case.
Okay, well, I don't know what's wrong with mine, but I don't see that question, so please let me know if someone has added one in WebEx. That's great that people are adding them. Do we have any on the lines now, Amy?
Not at this time.
Donna, there's another question. Is Great Britain part of the convention? At the moment, Great Britain is still a part of the European Union, and they are a party to the convention. We are in contact with the Central Authority in the UK and having some conversations with them. We should proceed with the convention once it enters into force for the United States, and we will notify you if there's a change to that. And but at this point, we anticipate for the time being, that you would process cases with the UK under the convention after January 1st.
And this is Liza Lowe. Just to add to that, practically speaking, we believe that processing cases under the Hague Convention will be a vast improvement in terms of procedure and forms and just reciprocity and being able to communicate with the other country. So we do believe that processing going forward, once we're party to the convention, that this processing under the convention, even if we previously had a bilat, will be much better for everyone involved. So we see another question.
Meg, I'm going to ask you to answer this one. The next question says, are cost-free services available to both parties?
So that's a really good question, and that was definitely what the United States delegation sought. There was not consensus on that, however. So a country has to provide effective access to procedures to both creditors and debtors, to both obligees and obligors. In terms of free legal assistance, that's required to applications from creditors, but that's not required for applications from debtors. So effective access, yes. Free legal assistance is to creditors only, unless a country wants to do more than that, which we certainly do in the United States.
Thank you, Meg. There is another question which says, you said there are 22 countries that were added. What are these countries? After the call is over, everyone will be receiving the PowerPoint with speaker notes and a more detailed Train the Trainer guide. We anticipate that will be available in 1 to 2 weeks. And you'll have this list in those materials, but I will share those 22 countries with you quickly. Albania, Austria, Belgium, Bosnia and Herzegovina, Bulgaria, Croatia, Cyprus, the Czech Republic, Estonia, France, Germany, Greece, Italy, Latvia, Lithuania, Luxembourg, Malta, Romania, Spain, Sweden, and the Ukraine. Again, I know that I went through that too fast for you to write down, but you will have that in the written materials fairly soon after this webinar. Meg, we have another question on costs. Do states that do cost recovery have to provide free legal services?
And I'm going to turn that back to you since that's a OCSC policy question.
I'm going to defer that question, and we will come back to that. And then the next question says, where can we get a list of all the participating countries? Okay, again, that will be in the materials after this call. We're going to provide, actually, in the latter part of the webinar, Liza's going to discuss some resources where you can click on and see those countries right now if you like. And what about the special documents that they may require for case processing and the time guidelines per case? So we're going to be addressing those issues, if not today, in subsequent webinars. So I'm going to hold off on that.
And can I just point out that later on, Eliza's going to go over how you get to the conference website, but there is a place you can click on to see all of the countries that have ratified the convention to date. So and that will always be up to date. So the Hague website will always have current information.
Donna, why don't we go ahead and go back to the presentation, and then we'll open it back up for questions at the end.
Okay, so Amy, you haven't had any on the line?
Correct.
Okay, great. So yes, please, if you are on WebEx, add any questions as we go, but now we will, I will turn it back over to Meg.
Thank you. So I'm going to shift gears just for a short period of time and talk about UIFSA 2008, because that is the implementing legislation in the United States for the Hague Child Support Convention. The good news is that all states have enacted it in virtually verbatim. So we have a uniform act that's truly uniform once again. So it doesn't matter whether you were 96, 2001, everybody now is playing by UIFSA 2008. There are some new definitions in UIFSA 2008 that are especially relevant to international cases, and I wanted to highlight two of those. UIFSA 2008 distinguishes between a state and a foreign country. So a definition of state includes tribes, but there is now a separate definition for foreign country, and that definition includes many, but not all, foreign nations. To meet the UIFSA definition of a foreign country, the country must be a foreign reciprocating country. So that would be, a country that the U.S. has a bilateral arrangement with. It must be a country with which the foreign state has a reciprocal arrangement. So that's talking about state reciprocal arrangements that have been around since the 1960s and UIFSA days. Usually it's the Secretary of State in your state that has a list of the countries that your state has a reciprocal arrangement with. A foreign country can be a country with laws substantially similar to UIFSA, and a foreign country can be a convention country. So a foreign nation has to meet one of those four sub-bullets to meet the definition of foreign country under UIFSA. In UIFSA 2008, you're also going to see this phrase, outside this state. And that means another state, a tribe, a foreign country, a foreign nation. It's basically anywhere other than your state. You'll see that phrase especially in the evidentiary provisions of UIFSA. Next slide. One of the unique provisions of UIFSA 2008 is the roadmap that's in Section 105, and it's basically giving a clear direction to tribunals about what parts of the Act they should be applying to an international case. The tribunal has to apply UIFSA Articles 1 through 6 to a support proceeding involving an order issued by a foreign country, a tribunal of a foreign country, or a party or child residing in a foreign country. So Articles 1 through 6 are basically UIFSA like you were used to operating under prior to the 2008 changes. And keep in mind when there's a reference to a foreign country, we're talking about a country that meets UIFSA's definition of a foreign country. Section 105 also provides that if a tribunal is recognizing an order on the basis of comity, which is a case-by-case decision, the tribunal may apply UIFSA Articles 1 through 6, but it's not mandatory. So let me talk a little bit more about comity, since that's a legal term that a lot of people aren't familiar with. Comity is a willingness to recognize an order out of respect, not as a matter of a legal requirement. So if there's a support order that's issued by a country that's not a foreign reciprocating country or not a convention country, then a U.S. tribunal may decide to recognize it and enforce it on the basis of comity because the foreign court complied with our concept of due process. It's not legally required to, but it can choose to do so. And it's something that's done on an order-by-order basis, not on a country basis. So what that means is if the court in your state recognizes an order from, let's say, Tunisia on the basis of comity, and 2 years later a different order in a different case comes from Tunisia, it's like the court starting all over again. It has to decide whether to recognize that new order on the basis of comity. So keep in mind that the two important things is comity is not legally required. It's something a court does out of respect because it's found that the order meets due process. And the second thing to remember about comity is that it's on a case-by-case basis, doesn't cover the entire country. So the third thing that Section 105 addresses is what a tribunal should apply if the order comes from a convention country. And if it's a convention proceeding, the tribunal has to apply the new Article 7 of UIFSA. If there's not any conflict with Article 7, then the tribunal will also be applying Articles 1 through 6. So, for example, the evidentiary provisions that are in Article 3 also apply to a convention case. But Article 7, this new article, only applies to applications coming through the Hague Child Support Convention. And because of that, it means that Article 7 only becomes effective on January 1, 2017. So even if you are currently using UIFSA 2008 in your state, you should not be using Article 7. That will only become effective on January 1, 2017. Next slide. Another UIFSA provision that's important in international cases, including convention cases, is Section 316. And this is the main evidentiary provision within UIFSA. One of the provisions within Section 316 replaces the requirement that previously was there that required a person to swear under oath before a notary in order for information in a document to be admissible into evidence. What Section 316 says is that an affidavit or a document which would not be excluded under the hearsay rule if given in person is admissible in evidence if it was given under penalty of perjury. And that applies if the person is a non-resident, a party or a witness residing outside the state. So this signing something under penalty of perjury is reflected in the revised federal intergovernmental forms. You're gonna see that in that context. How this provision plays out in Hague Convention cases will be the subject of a later module. But I do want you to be aware of that change to penalty of perjury. Another place where Section 316 applies that will help in international cases is the encouragement to take advantage of modern methods of communication. So it authorizes the transmission of documents from outside the state by telephone, telecopier, or other electronic means. Another big change is the requirement that tribunals must allow a witness or a party residing outside the state to testify by telephone, audiovisual means, or other electronic means. So it's no longer discretionary. The tribunal has to allow telephonic testimony, and obviously there's some issues in international cases. We'll talk about that requirement and those kind of implementation issues in a later module. Next slide. The phrase outside this state also appears in Sections 317 and 318 of UIFSA. Section 317 authorizes a tribunal in your state to communicate with a tribunal outside the state. And that means communicating with a tribunal of another U.S. state, a foreign country, or a foreign nation that doesn't even meet the definition of foreign country. Any tribunal that's located someplace other than your state. That communication can be about laws, the legal effect of an order, or the status of a proceeding. Section 318 authorizes a tribunal in your state to help a tribunal outside the state with the discovery process. So 316, 317, and 318 apply to cases between states, but there are also very important provisions to international cases as well. Next slide. With these next slides, we're going to shift from UIFSA and focus back on the Hague Child Support Convention. I want to talk about the mandatory scope of the convention so you'll know what to expect on an outgoing case. I mentioned earlier some of the negotiation discussions that took place. One of the early discussions was on who should benefit from the new convention. Should it just cover child support? Should its scope be expanded as widely as possible to also include spouses and adult dependents? I mentioned what the U.S. goal was in terms of the scope. And the final compromise really wasn't reached until the last diplomatic session. Some things did get decided early on. For example, the delegates all agreed early on that the convention should cover enforcement of child support. But even, within that, there was discussion about whether the convention should include establishment of parentage, what the age should be for a child within the mandatory scope. And ultimately, the decision was made that the mandatory scope should cover the establishment, enforcement, and modification of child support, and that there was an obligation to recognize and enforce a foreign child support order up to age 21. If a country wants to limit the scope of recognition and enforcement to children just to age 18, it could do so, but the convention requires that to be done by a reservation. So a reservation is a unilateral statement that a country makes when it's ratifying the treaty, and it's saying whether it's excluding or modifying the legal effect of a certain provision of the treaty. And in the Hague Child Support Convention, it allows a contracting state to make a reservation with regard to that mandatory scope of recognition and enforcement to age 21. And it allows a country to make a reservation to limit the scope to age 18. If a country does that, it means that limitation applies when it's sending a case as a requesting state. It also applies when it's a requested state. So there may be some convention countries that make that reservation, but the United States did not do that. The convention also covers the establishment of parentage if necessary to establish a child support obligation. So keep that second part in mind, because there was not consensus for there to be mandatory coverage of a parentage-only action. So an action to establish parentage only is not within the mandatory scope of the convention. Parentage establishment has to be necessary in order to establish a child support obligation. And then let's talk about spousal support. Recognition and enforcement of spousal support is within the mandatory scope if the spousal support is in conjunction with child support. And as I mentioned, the U.S. really pushed that linkage because that's what 4D covers. If the application is related to spousal support only, it's still within the scope of the convention, but there's no requirement that the central authority in a country perform services related to those applications. So a spousal support only application would be handled as a direct request to a tribunal. It would not be anything that in the United States would go through the 4D agency. Next slide, please. I mentioned that the scope of the convention didn't get resolved until the very end, and that's because in the final stages of negotiation, a group of Latin American states pressed to include maintenance obligations for vulnerable persons, and that's defined as anyone who is unable to support himself or herself due to a physical or mental impairment. So They wanted maintenance obligations for vulnerable persons within the mandatory scope. That was something that delegates couldn't reach consensus on, and I think in large part it was because it didn't come up until the very end. So a lot of delegates felt that they had not had sufficient time to examine the full implications of including that in mandatory scope. So the consensus was that it should not be included in the mandatory scope of the convention, but that countries should have an option to be able to expand the convention to cover vulnerable persons. So it's within the optional scope of the convention. Likewise, a contracting state may declare that it's expanding the scope of the convention to any maintenance obligation arising from a family arrangement, such as grandparents or an uncle. And there are some countries that do have a pretty expansive scope in terms of support obligations. So both of those are within the optional scope of the convention that a country can declare it's going to extend the convention to cover. Any of those kind of declarations apply to two contracting states only as long as their declarations are mutual. The United States did not make any of these declarations, so we will not be extending the application, the mandatory scope, to vulnerable persons or to maintenance obligations arising from these other family arrangements. Next slide. Because the convention applies to countries with a lot of different types of legal systems, it includes terminology that differs from the terms we use in the United States. So what this slide tries to do is convert, if you will, convention terms to their equivalent U.S. terms. So just to go through some of them, for example, when the convention refers to a creditor, it's referring to the individual entitled to receive support. In the United States, I think most states would refer to that person as the obligee or the custodial parent. And in some cases, the creditor may be a public body like the 4D agency. When the convention refers to a debtor, it's talking about the individual responsible for paying support. In the United States, most states would use the term obligor or non-custodial parent. Probably the most confusing term to us in the United States is the convention's use of the word state with a capital S, and I mentioned that earlier. When the Hague Conference talks about a state, it's talking about a country. So when it refers to a contracting state, it's referring to a country that has ratified or approved the convention. And what you'll see in the United States, just to not have that confusion, we'll usually refer to that as a convention country. Another term that's a little bit different is that the convention uses the term maintenance, whereas in the United States, we obviously use the term support. In the convention, you'll see reference to requesting state and requested state. Again, state means country. Those are similar to how we refer to an initiating state and a responding state in an intergovernmental case. So a requesting state is a country that's requesting services from another convention country, and the requested state is the convention country that's responding to that request. For the most part, in implementing the Hague Child Support Convention, UIFSA 2008 uses words that hopefully you're familiar with. So what you will see, for example, in Article 7, where the convention talks about recognition and enforcement of a support decision, Article 7 talks about recognition and enforcement of a registered support order, since we're used to the registration concept. There are a few additional definitions that you'll see in Article 7 that are there because of the convention. One of those is a definition of central authority that we're going to talk a lot about in the next module. Another term that you will see defined in Article 7 is foreign support agreement. That's the last bullet on this slide. What the drafters of UIFSA are trying to do is rephrase what the convention calls a maintenance arrangement. So a maintenance arrangement under the convention and a foreign support agreement under UIFSA are talking about an agreement for support that's enforceable as a support order in the country of origin. It's not the same thing as a separation agreement that we have in the United States, because those are just enforceable as a contract. Foreign support agreement is actually enforceable as a order in the country of origin, and it's been authenticated by or filed with a foreign tribunal. So it's different. And Section 710 of UIFSA does discuss the process for recognition and enforcement of one of these registered foreign support agreements. So with that, which is a kind of a quick overview of some of the terminology from the convention that you'll see reflected in UIFSA, I'm going to turn it over to Liza, who will talk about some resources to help you further understand the convention.
Thank you so much, Meg. I'm going to keep going, but we are seeing lots of questions coming in on the Q&A, and several that are related to the scope, the mandatory scope related to the age of emancipation. And states have questions about what they are supposed to do and what they will be required to do if they have different emancipation ages in their state. So we will, in a few minutes, have a chance to address some of those questions. And keep your questions coming. So thanks so much, Meg. We wanted to take the opportunity to share a few resources that are available to learn about the Hague Child Support Convention on your own at this point. The best place to start is the website for the Hague Conference on Private International Law, and Meg has already referenced that previously in the presentation. The URL for the website is www.hcch.net, and you will see that on the next slide. But on this slide, you'll see that there are two official languages used by the Hague Conference, English and French. And for resources in English, you simply click on English, and you will be brought to the convention homepage in English on this next slide. On the left column of this homepage, you will see a list of topics for which the Hague Conference has developed conventions. So child support is not nearly the only one that the conference works on. Click on child support in order to reach all the resources related to the convention that we're interested in, the Hague Child Support Convention. And you'll see on the slide down in the lower left-hand corner, we've made a little red arrow for you and the two children on the icon right down there, and just click on there. On the next slide, you will come, it'll take you through to the child support section. And this is a partial view, of course, of the child support section on the Hague website. And below, if we were to scroll down, you would see a long list of all kinds of resources related to the convention, how to implement it, who's involved, the countries, resources, etc. In addition to the convention text on the website, you can access also the explanatory report. And this report explains the development of each provision of the convention and explains the consensus reached, as Meg described the process earlier. So it's very useful. It's particularly useful and interesting for lawyers and decision makers to see how the consensus was reached, how we got through the negotiation process to the final convention. The Hague Conference Child Support website also includes links to the mandatory and recommended forms for use with convention cases, and I saw a question come in about forms. Subsequent modules of the webinar will discuss these forms in relation to applications for establishment, enforcement, and modification. And just to address the question now, you can find the forms listed on this Hague Conference website. You'll find those attachments and also some other resources. We have been going through the process of a Paperwork Reduction Act process to clear the Hague Convention forms for use on January 1, 2017, and we do have a Dear Colleague letter on our website that discusses the forms, gives you a link to some guidance, gives you links to the forms and other useful links, so do take a look at that, and that's a good resource if you're interested in looking at the forms and what's happening with the forms as far as OCSE is concerned. There was also a question about language, and we're working on bilingual forms. We hope translation will be an issue we will probably talk about later on, but we will have the forms available, and the whole idea of the forms is that the way they're developed under the Hague Treaty is it minimizes the need for translation, so they should be easier to use. In order to ensure effective implementation of the Convention requires each contracting state to provide the Permanent Bureau with a description of its laws and procedures governing maintenance obligations. And one way it can do this is through completing what's called a country profile. And this is listed on the Hague website as well. The country profile is based on the U.S. Intergovernmental Reference Guide, the IRG. So this concept is very familiar to U.S. states who use the IRG regularly to find out laws and procedures in other states. Now, in addition, on this country profile, you'll find central authority contact information for the country. It contains a country's responses to questions about a number of topics, such as parentage establishment, support guidelines, enforcement methods, and the collection and disbursement of support. Responses are standardized checkboxes, but there's also spaces for free-flow text as well. Because the profile responses are available in English, it's really a great resource for 4D caseworkers and attorneys. And if you do, when you get on the Hague website and click through to the country profiles, you will see a really nice long list of all the countries that are under the Hague Convention for child support, and you will see you can check on English or French, or the country profile will come up in the language that you wish, and most of them are available in English, so it's really interesting to look through. The United States has completed its country profile, which informs other contracting states, our foreign partners, about child support laws and procedures in the United States. Our responses include links to the IRG, so contracting states can learn information about laws and procedures within individual U.S. states. And some of you who are familiar with your state IRG responses will know that we do have several new questions on the IRG, and those have been posted specifically so that we are providing the information we need to in the country profile. So when countries click through to our IRG, they can see the information that they needed or expected to as part of the country profile, sort of the next layer down from the country profile. Another very practical resource is the Handbook for Caseworkers, and it was written by Hannah Roots, a child support attorney in British Columbia who often speaks at U.S. child support conferences and is maybe recognizable to many of you. The handbook explains the convention's provisions. It has flowcharts related to case processing, and most importantly, it provides step-by-step instructions on how to complete the recommended and mandatory convention forms. So it's a great resource. And the link to that section, or explanation about how to get to that section of the handbook, is also in our Dear Colleague letter about the Hague forms. So moving on to the next slide, we have here our information from OCSE. So the Federal Office of Child Support Enforcement has also developed a number of resources related to the Hague Child Support Convention, and most of them can be easily accessed through the international page of OCSE's website. And we have the link there on the top of the screen, and I hope if you haven't gone to it earlier to find out about bilateral agreements or what's happening with the Hague implementation and ratification, you will go to that sometime soon because that will be a main opportunity for us to share with you information about implementation of the Hague Treaty. And in particular, and Donna will say this at the end, not only will you be getting the resources for participating on this call related to this call, such as the webinar training materials and the PowerPoint, but we will be posting those materials on our international website too. So it's really a useful place to go to find out what we're offering in terms of implementation guidance. Now, OCSE's Division of Policy and Training has issued several policy guidances. I've already mentioned, for example, the Dear Colleague on the open comment period, and there it is, DCL 1621 on the slide. That's related to the forms. But we also encourage you to take a look at particularly IM Information Memo 1602, which provides an overview of provisions of UIFSA 2008 that have the most significant impact on 40 caseworkers and attorneys. And also an older information memo, 1501, it's in a question-response format, and it addresses questions related to 3 topics: convention, provisions, and requirements, the U.S. involvement in the development of the convention, and convention countries and the process for ratification. The division, our division at OCSE, will continue to address implementation issues on an ongoing basis, and in particular, we expect to be issuing new policy and information in the coming weeks as we get closer and shortly after January 1st. So at this point, we're going to stop and take some Q&A, and I think I'm going to hand it over to, well, we're going to read some questions. And Donna, do you want to cue Amy?
Pardon?
Do you want to cue Amy for the questions?
Oh, Amy, do we have anyone who wants to ask one on the phone, which is *1?
There are no questions on the phone at this time.
Okay. So I'll need to turn it back to you, Ann or Liza, to read them. I still don't have the ability to do that on my screen. Apologies. Ann, do you have some that came in through WebEx?
This is Meg. I don't know what happened to their line, but they did forward me some of the questions that have come in. So there are a few that I can raise and answer until the federal office is able to join back in. Would you like me to do that, Donna?
That would be perfect.
Okay, so one of the questions was, well, several of them are related to the age 18. One of them was, did the U.S. file a reservation to limit the application to age 18? And the answer to that is no. Another question was, when an order is entered in Poland, the order becomes payable. Well, let me just stop with. Let me skip to another one. It says, how does the mandatory scope to age 21 impact a state whose emancipation age is 18? Does this require a state to provide a different service than international applicants? And I think the problem is that the slide, the way it's set up, is a little bit confusing. The mandatory scope is the convention has to apply to maintenance obligations arising from a parent-child relationship toward a person under the age of 21. And when you read the explanatory report, it's clear that you have to be able to establish, enforce, and modify child support obligations. But the age 21 has to do with recognition and enforcement. So it's very similar to what we already have in UIFSA, which is even if your state's law limits to age 18, you have to enforce another state's order up to 21, if that's what the duration is in that order. So the mandatory scope in terms of recognition and enforcement is age 21. There is nothing in the convention that is going to require a U.S. state to change its age of duration. So I just want to make that clear, and we'll try to make that clearer on the slide before we finalize the slide. Another question was, when an order is entered in Poland, the order becomes payable to the child reaches age 18 or they become self-sufficient. Based upon this treaty, is it expected that the U.S. will end the obligation at age 21? This is a really good question. I can tell you what the convention says, and then I anticipate OCSC issuing policy guidance. The convention, as I said, limits the mandatory scope of recognition and enforcement to age 21. So that's what the convention requires. We have UIFSA, and as you know, UIFSA has a choice of law provision that talks about applying the law of the issuing state or country. So I think that's where you're going to get kind of an interesting question that is going to come up. And because an order is enforceable for a longer period does not mean the child support agency has to provide services in that case. So I think the question about these Italian orders and Polish orders until the child becomes self-sufficient, I anticipate OCSC will issue guidance about what the 4D agency's role is in those cases. Is OCSC back on the line yet?
Hi, Meg. Thank you. I apologize. We had a technical problem and fell off the call there for a minute. Meg, is the one question left, the reservations?
Yes. What reservations do the U.S. file?
Okay. In our instrument of ratification, the U.S. took a reservation to exclude 3 bases of jurisdiction for recognition and enforcement of support orders. And these 3 bases were not consistent with U.S. law on the minimum contacts required for jurisdiction in order to satisfy our constitutional due process requirements. So they basically related to the creditor-based jurisdiction. So we took a reservation on those 3 bases, and we also took a reservation objecting to the use of French in communications between central authorities of treaty countries. So communications with the U.S. should be in English.
There was another question that I did not address yet. I don't know if you want me to answer, if you all want to answer it, Anne, and that is, can an arrears-only case in which the child is over 21 be sent to other countries or received under the convention? I don't recall the convention addressing that because the convention only requires recognition and enforcement up to age 21. So I don't think the convention addresses arrears-only cases where the child is over 21.
And the really nice, this is Anne, the nice thing about the training is we'll get questions we haven't received yet, and we have not, this is the first time we've been asked this. So in future trainings, and we'll try to address this in the December training, we'll take a look at that question.
And this is Liza. To that point, I see a question about someone's requesting a Q&A, a copy of that from today's call. So as Anne said, we will make sure that we're addressing these questions, and we probably won't have a Q&A sheet available to you with answers anyway shortly after this call, but we're really glad to have all these questions, and we will be incorporating them into our guidance and trainings going forward. I also see some more questions about forms. When will the forms be available? Will it be before January 1st, 2017? It's an excellent question. That DCL that I mentioned does have links to the forms, and the forms are not changing. So the Hague issued, 2 what are called mandatory forms and then 12 recommended forms. The content of those forms will not be changing. We won't be able to change them. Therefore, you can look at them in their final form at any time you want to access them. Please do read that Dear Colleague letter. I see another question here that says, do we need to use the recommended forms, or can we utilize current UIFSA forms for case processing with convention countries? And then in parentheses, it says, while understanding that 2 of the forms are required. Again, there's information on the Dear Colleague about what the terminology is a little confusing or different, that Hague uses mandatory and recommended forms. And that's because 2 of the forms, if I have this right, Meg, were part of the convention. It's part of the convention itself, the 2 mandatory forms. The recommended forms were hashed out in a very long process, which Meg had a leadership role in. And so they're only called recommended because maybe down the line, the Hague Conference will get back together and change the forms. But in any case, as far as we're concerned and as far as our perspective will be, that we're going to be using all of those forms, all 14 of those forms. So it's important to look at all of them. And we do anticipate that you will be using Hague forms for convention cases and not UIFSA forms. That's our operating stance right now. So I do commend to you the Dear Colleague letter. Take a look at that and shoot us any questions you have about forms, and we'll have more information on that certainly before January 1st.
And just to supplement what Liza's saying, one of the things that is discussed in that OCSC policy guidance document is that when you're sending an outgoing case to a convention country, you need to look at their country profile, because there is a place in the country profile where a country will talk about what forms they want you to send to them, and they can check whether they want you to use one of the convention recommended forms or a form that they have developed specifically for their own country. So, just like on our country profile, the U.S. will tell other countries we want them to use the Hague Convention recommended forms. But on outgoing cases, you'll be able to look on, let's say, the country profile for France and see what forms they want you to use for an outgoing case.
Thanks, Meg. There's another question that says, what is the status of Mexico's participation with the convention? Mexico is not a party to the convention, and we're not aware that they are close to becoming one. We have a meeting with the State Department on Monday, and we will certainly inquire if they've heard any further updates about Mexico. And then the next question says, when are the new federal regs based on the proposed in 2014 going to be released? I believe this is referring to the flexibility, efficiency, and modernization notice of proposed rulemaking, and I do not know the answer to that question at the moment. I know they're looking at it closely. It is at OMB, but we don't have a date at this point. Are there any other questions? Donna, that's everything in the Q&A.
Okay, Amy, do we have any people waiting on the phone?
Yes, we do have one question. I believe the name is Dia. Your line is open.
It was Lydia. You answered my question. Thanks.
Oh, sorry about that. I didn't quite get your name.
Okay, is there anyone else who would like to ask one on the phone? Go ahead and press *1. If we don't have any more, we certainly appreciate all the questions you've asked. As the presenters have already commented, it really helps when we get your questions, because then we understand what more we can add to the materials so that they're really more useful.
Ma'am, we do have a few more questions.
Perfect.
We have one from Danielle Lewis. Your line is open.
Our question is, if we are asked to establish a case or establish an order for both child support and spousal support, does the Child Support Office have to get an order for spousal support?
And do you want to address that? There's nothing in, the convention doesn't require for the agencies to do anything contrary to federal regulations. The question is,
it would be the same as in a domestic case if you were asked from another state to establish child support in conjunction with spousal.
Okay, thank you.
And I think we had more people in the queue, Amy?
Yes, I have another question from Lydia Scales. Your line is open.
Currently, we have an IRG interface with SESNet that provides FRC addresses. Will we continue to receive address information for all participating countries through this interface?
That's a great question. We do, right now we have information about addresses in 2 places, and these are for our FRCs. This is not convention countries. We have address information on that international web page that I mentioned, and it's very clear laid out. And then identically, we have information, that same contact information is on the IRG. So I'm assuming whenever the IRG gets updated, you get a notification. Is that what you're saying? Well, in any case, once we will be maintaining all of that. And in addition, the convention countries I see are starting to populate the IRG, so we will probably have contact information for convention countries too. But as a real fail-safe place to look as well is those country profiles, because the first thing they will have on their country profile is that central authority contact information, and that's under our FRC BILABs, you are communicating with the central authority. So we will be sorting all those out, but I do see that is populated. The convention countries are starting to be populated on the IRG, and so we'll get that up and running. But nothing should change with the FRC process at this point. So we'll learn more, and please do prompt us if you have questions or you have suggestions.
Amy, do we have another question?
Yes, we have a question from Danette. Your line is open.
Hi, Ann. It's Jeanette in Colorado. Hey, we may not know the answer to this yet, but it's related to the arrears questions, and I know we're going to get this question from our counties, and that is that if we already have a case under the Hague with a contracting country and the child then turns 21, so the case turns into a arrears only, or the child is over 21, does that case stay open? So I know you may not have the answer to that yet, but that's something to sort of add to your list.
All right, Jeanette, thank you. We'll definitely do that. Where is the order from in your example?
Well, I think it could be either direction. I mean, I think it could be one where we're the requesting state or one where we're the requested state. I think it could be either way.
Okay. Instead of taking a guess, I'll hold off and we will answer that hopefully in the next training in December.
Yeah. That's fine. I just wanted you to put it on your radar.
Thank you. Donna, we're getting close to the ending time, and I know there are still some questions, but we will be happy to take a look at those and put those on our presentation for December and come back to those. So would you want to go ahead and wrap up?
Yep, absolutely. So yes, for any of you who are waiting on the phone too, if you can send me your questions or anyone else that's been presenting, we'll make sure and get those answered at a later date. But if we could go to the next slide. we've put on here that the next 3 of these webinars have been scheduled. So if you're interested, be sure and put them on your calendar, but we won't be sending the links to the registration until a few weeks before each one, just so that we don't end up with the best calendar we can get to. So, you know, again, we want all your questions, and you know, because then we can incorporate them in future ones. And then if we go to the next slide, here is the 2 contact addresses that you can use. So make sure you can send your questions or feedback there. We're very interested in it. And as we've said earlier, there will be not only the recording from the training today and the presentation, but there will be trainer notes and kind of expanded train the trainer notes. And we really hope that you're going to find these materials useful and use them for training staff. And so those will be available shortly. We'll email out what we can, and we will be posting them to our website too when they're ready. So I want to thank our presenters today. So thanks to Ann, Liza, and Meg, and I want to thank all of you for participating. Have a great day.
Thank you. That concludes today's conference. You may disconnect at this time.